Senator Claytor calls from the calendar House Bill number 264 by Representative Mack. It is enactment Title 15, relative to juvenile parole eligibility.
Senator Claytor.
Thank you, Mr. President.
We got 2 separate amendments on this one, Cooper. Got these out?
All right, members, this is the juvenile life bill that we've seen twice before. Danny and I spoke a little bit about it yesterday. Just as a kind of a refresher on how we got here, in the United States Supreme Court case of Roper v. Simmons back in 2005, the Supreme Court said that the Eighth Amendment against cruel and unusual punishment bars capital punishment for juveniles, people under 18. Thereafter, in 2010, in Graham v. Florida, the Supreme Court once again said that it bars a life sentence without the possibility of parole for a juvenile convicted of a non-homicide offense, rapes and kidnapping. Along came Miller in 2012, and it extended Graham beyond rapists and kidnappers to include first and second degree murderers who are under 18, and it said that they may be eligible for parole consideration if, after a hearing, a judicial determination has been made that the person is entitled to parole eligibility. Miller was finally, well, not finally, because nothing's final in the U.S. Supreme Court, followed by Montgomery. And in Montgomery, that was Montgomery v. Louisiana, so it was directed directly to us in the state of Louisiana. It said that those that were convicted of a homicide, a first or second degree murder, should have consideration for parole. And essentially what it did was it made Miller retroactive. So in Montgomery v. Louisiana, the court gave us some direction as it concluded its opinion and said, giving Miller retroactive effect, moreover, does not require states to relitigate sentences, let alone convictions. In every case where a juvenile offender received mandatory life without parole, a state may remedy a Miller violation by permitting juvenile homicide offenders to be considered for parole rather than by resentencing them. Allowing these offenders to be considered for parole ensures that juveniles whose crimes reflected only transient immaturity and who have since matured will not be forced to serve a disproportionate sentence in violation of the Eighth Amendment. The way it currently stands is those offenders, well, the way the bill is written in response to Miller, gives those that are homicide offenders, killers, an opportunity at parole after 35 years. That language is captured in Louisiana Revised Statute 15:574.4 as in parts D and E as it relates to killers and life sentences. We should also be aware of Code of Criminal Procedure Article 878.1, where it says sentencing hearing for a juvenile offender in any case where an offender is to be sentenced to life imprisonment for a conviction of first-degree murder or second-degree murder, where the offender was under the age of 18 years at the time of the commission of the offense. A hearing shall be conducted prior to sentencing to determine whether a sentence shall be imposed with or without parole eligibility, pursuant to the provisions of 15:574.4E. At the hearing, the prosecution and defense shall be allowed to introduce any aggravating and mitigating evidence that is relevant to the charged offense or the character of the offender, including but not limited to the facts and circumstances of the crime, the criminal history of the offender's level of family support, social history, and such other factors as the court may deem relevant. Sentences imposed without parole eligibility should normally be reserved for the worst offenders and the worst cases. That's the way the bill's written. That's the stance that it's currently in. I see no questions, but I do believe there may be an amendment or two lurking out there.
All right. You have amendments, Mr. Secretary?
Yes, sir. I have amendments by Senator Luno. Senator Martini's first. Amendment sent by Senator Martini is set number 3827. 3827.
All right. Senator Martini.
Thank you, Mr. President. Members, if you'd give me your attention, I was listening to Senator Claytor speak, and I'm afraid that if we had a test on what he said, none of us would pass it. And this is some pretty serious stuff that we're talking about here. The United States Supreme Court, in the case of Montgomery versus Louisiana, said we have to have, as Senator Claytor stated, it was cruel and unusual punishment to sentence these people. And again, they're convicted of first and second degree murder at a time when the crime that they committed, they were under 18. And they were given life imprisonment without probation, parole, or suspension of sentence. The Supreme Court said, can't do that. Supreme Court said, you have to go back and you have to give them some meaningful opportunity to make the call whether or not they were the worst of the worst, as Senator Claytor would say. And I believe the bill in its original form provided for a remedy for those people that were convicted prior to, I think the date in the bill is 2012. And the reasoning that was employed by the Supreme Court in making that decision, and that's the part, that's why we're allowing them to do it, provided that they have been incarcerated for more than 35 years, and they reach those other benchmarks that are mentioned in the legislation. The reason they did that was because the Supreme Court, one of the arguments was that the juvenile brain has not really matured enough, and that's why we wait 35 years to see whether or not the person who committed this heinous crime, and I'm not here to defend the crime, but the person who committed this crime, perhaps over that 35-year period, had changed substantially enough to where we would give them parole consideration. The problem is, going forward, the existing law says you have to give them a hearing, and it doesn't specify when you have to give them the hearing. And in speaking with the representatives of the DA's Association, they say we ought to have the hearing right now. Once they're convicted, once they're sentenced, let's have their hearing right now. And that's in compliance with current law. The problem with that is you've got the people who were convicted more than 35 years ago. They're being judged by a completely different set of standards than the people now. Now, granted, 35 years is a long time, and you always have the possibility that, in all probability, the victims aren't going to be around or whatever. But we're dealing with that problem right now anyway, with the people retroactively. What my amendment does, it applies the same standard prospectively. And it says, if you're convicted, you're given life, and if you meet those same 35-year standard, the 35 years of incarceration, then the parole, then you can, if the court decides that you warrant parole consideration, it can be given. That's simply it. That solves the problem. The problem that you have now is that there's no specificity. All those factors come into play, but the problem you have now is you're going to have the DA or the judge determining whether or not this person may possibly change in 35 years. So all my amendment does, it deletes the sentencing hearing phase prospectively and says, We will treat everybody, every juvenile, every person who commits first or second degree murder and they're under 18 years of age at the time of the crime, they will be judged by the 35 years and the other benchmarks that are mentioned in the bill. I'll be happy to answer any questions.
Senator Mills, you had a question?
Senator Martini, this, and I marked this up, does this get rid of all of these sections as far as the GED requirements, and does that do that?
No, it doesn't do that because that was my question. Those requirements are in the statutory law that
So
it's existing law 15574.4.
So it refers to that in the amendment.
Yeah, so we're not lessening it. It's the same. Okay. I see no questions. I'll move adoption of the amendment.
All right, Senator Clay, do you have any objection? All right, you want to speak?
I hope although it's certainly very serious, I hope the irony of Senator Martini arguing for prospective application isn't lost on everyone, and that ordinarily he's trying to get in the way of retroactive application. In this case, just to go back to the beginning, the Supreme Court has said that you have to offer an opportunity for parole consideration, and we've set up the mechanism, and I certainly understand Senator Martini's argument that if you're going to do it retroactively, why aren't you doing it prospectively? The reason is, on the retroactive side, we're talking about 300 some odd people, cases that are 35 years old, cases that are 25 years old, cases that are 10 years old. Mr. Montgomery, I want to say that case is well more than 35 years, if I remember correctly. That's from here in Louisiana. That's from right here in Baton Rouge, Mr. Montgomery. Frankly, like a lot of things that we do here, we don't have the resources to go back and have these hearings, sentencing hearings on the 300 or so folks. As I read to you earlier on the test that Danny wanted to apply, the Supreme Court said in their decision, you can handle that by just making everybody parole eligible back in that period. So as a practical, fiscal, financial matter, not always the reason to make all of our decisions, but practically, we can't go back and have the hearings on those that have already occurred. It's too expensive and we can't do it. But as we move forward, the law is well written as it is right now, and it leaves open, and this is the point I want to make, it leaves open the option to give a life sentence for the worst of the worst. That is who we're leaving the door open for, is that narrow group of juvenile killers. I'm not talking about armed robbers or rapists or kidnappers. I'm talking about killers. It leaves open the door to incarcerate them forever. So that's what the choice is. And I can respect a decision either way, and certainly want to answer the questions, including Senator Martini's, but I think someone's before you.
All right, Dr. Thompson, you want to ask him a question?
Well, I think y'all have got it about as confusing as it can be when you think Senator Claytor. But the question I have, what are the DAs, what are the judges, what are the sheriffs, where do they stand on this issue? You know, many times we're often have these debates, and it's a good idea to know where they stand on these issues.
Well, The answer is the Louisiana Association of the Defense. I'm sorry. The DAs, their association is for the bill as it's written, without amendments, according to the paperwork that they've shoved out across the floor to the various members. As far as judges, I hadn't gotten a note that said what the judges for or not for, but I can tell you that they provided information along the way as far as how it would happen and the costs that are necessary for the bill right now. We cannot afford to do nothing as far as that's concerned, but I haven't seen a note as it relates to Danny's amendment as it comes from the judges. I have seen it from the District Attorneys Association.
Now, the only one you left out was the Sheriff's Association. Do you know about them?
I can't say that I've seen a note from them, but one thing that sometimes it certainly helps some folks make a decision, but when folks come in here and say the DAs, the sheriffs, defense attorneys, and everybody has reached a compromise, that doesn't mean that garners your vote or my vote. That just is helpful to a decision, but we still have to make a decision for ourselves. So I can't answer whether the sheriffs are for it or against it.
Well, 2 out of 3 is not bad. What I would suggest that it's not always something that might change your mind, but when you have compelling information on both sides, good techniques, good outcomes suggested by both sides, and then with the thought of a constitutional amendment, a constitutional quagmire of sorts, I think it's a good idea to see what those that are actually be handling cases or those that have placed people in these positions and those that make the first arrest would have a lot to say about who and what we're doing to those folks.
Yes, sir. I can tell you as far as providing additional information as it relates to the district attorneys that when we heard the bill in committee, Van Kaiser, the DA from up in Natchitoches, came to committee and he brought a family that were the victims, their family members of the murders. And they were very concerned about having to go through the process again and that they had been told this guy was never coming out. And then the U.S. Supreme Court says, well, he's going to have a hearing. It doesn't mean that folks are necessarily coming out and that they will have a hearing before the parole board and there'll have to be a vote. But folks that have, I can't imagine a deeper scar than having a family member murdered. I can't imagine that. And so you have to come to the courthouse again or to the parole board again for these hearings and go through that process. It's an ugly, difficult process that has just done some families in, and there they got to come and live it all over again. So as far as those 300 that have happened in the past, there will be a parole hearing, but at some point, but there may not, there's no need for the court hearing that we're talking about. As it goes into the future, though, I think we have the resources to handle it as we go into the future as it is.
Right. Could you tell me how many members they have on this very powerful parole board?
Well, we've been fiddling with the parole board lately, and we're talking about 3.
3 members. And how many out of those 3 could make the decision? 2 of them? Or does it take all 3?
There's been discussions about in our general session about whether it has to be all 3 or 2 out of 3. We had some other bills that came up that haven't made it out of here. As it currently stands, 3 out of 3.
3 out of 3.
Senator Martini, you had a question?
Is there anything in the present law that stops them from pointing out who the worst of the worst is? as far as, I mean, is there anything that prevents them, if this bill passes, from going to the prosecutor and the victims and all these victims' rights groups, going to the parole board and arguing this guy is truly the worst of the worst?
There's absolutely nothing that keeps the prior folks from coming to the parole board, and there would be nothing that would keep people, unfortunately, we know it's going to happen again in the future, they would be able to go to the parole board. Yes, sir.
And if we pass the bill in its original form without my amendment on it, there is nothing that guarantees that any of those 300 people will be paroled, is there?
That's correct.
All right. On the amendment, all right, Senator Martini, you want to speak on it, Senator Morrell? Yes. Yes, come on now.
Pardon me, Mr. Claytor. All right, I'm going to try and take the legalese out of this and be very simple, very straightforward. So here's the deal. Supreme Court has said you cannot send a juvenile to jail for life, period. Supreme Court decision. The debate right now is the bill in its current posture says, pursuant to the Supreme Court decision, for those people who were incarcerated as juveniles prior to 2012, no life without parole. What the DAs would like is to say, but going forward, we still reserve the right to lock up juveniles without parole. See my first statement. Supreme Court says you can't lock up juveniles for life, period. This bill is here because the DAs attempted to do the same thing last year, where they tried to nuance the law and say, well, in this certain instance, we can still do juveniles for life. Supreme Court said no, which is why we're here with this bill this year. If you pass this bill without Senator Martini's amendment, you are allowing the Supreme Court to take this measure back up, tell us we did it wrong again, and send us back this measure back to us again. I'm going to tell you, as an attorney, I'm advocating us not waste money on legal fees to defend this law, which will not be adequate. Without Senator Martini's amendment, this will be back in front of the Supreme Court on an expedited docket, and it will get knocked down again, and we'll be back here again. The only difference is we won't have addressed the issue, we'll have spent all the money on the legal fees, and we will, in the midst of all the work we've done on juvenile justice reform, will once again be in national news for trying to continue to do something which has already been declared unconstitutional. I encourage you to please vote for Senator Martini's amendment, because without his amendment, this bill is not sufficient, and the Supreme Court of the United States will reject it again. Thank you.
All right, Senator Martini, you have a right to close on your amendment.
Thank you, Mr. President. Members, we've got two sets of considerations here. And as Senator Morrell pointed out, and as we all, and I believe Senator Claytor and I, we all agree what the problem is. But the Supreme Court came back to us, and the Supreme Court's reasoning had nothing to do with how much it's going to cost. We got a fiscal problem here in this state, and we have to take that into consideration. The Supreme Court said, as Senator Claytor said very clearly, to do what you've been doing to these juveniles is cruel and unusual. Therefore, you need to go find a remedy. Using Senator Claytor's logic, we can't afford to do it the way we want to do it, so we'll cave in on those, because it's only 300 in the past. So what we're going to do is we're going to take that part of the law that the Supreme Court has already told us is unconstitutional and apply that going forward. Why not solve the problem? There's nothing that prevents any DA, nothing that prevents any victims group to go before the parole board when it happens, and it's not going to happen. Well, I guess it would happen 35. It may happen 30-something years, but that's the system. That's the way we have chosen to deal with those that were convicted prior to or who committed crimes prior to 2012. All this bill does is apply it on an even keel, and it provides the 35 years. Nothing prevents anybody from contending that the worst of the worst are not going to stay in jail. They are going to stay in jail. But if you accept their logic was the reason we have to deal with this is because sometimes some of these 300 people are not the same person who were the worst of the worst 35 years ago. But if we pass just the bill as it is right now, and not my amendment, tomorrow when they convict somebody, they can make the call, and we want the judge to say, this individual who was under 18 at the time he committed this crime, we're going to make the call right now that he's not going to have changed in 35 years. That ain't right. And as Senator Morell pointed out, we're going to be back. Now, I know there's another amendment coming up here. I told him I can't necessarily be for that 25 years because I gave my word I wouldn't be. But I told him up front. I told Pete Adams, Pete, I'm going to go with the amendment to make it all. He said, look, I understand. I'm not trying to hide anything from anybody. I'm not trying to do anything wrong. I think it's fair. I think it's the right thing to do. And the Supreme Court has told us it's the right thing to do. Please adopt this amendment.
All right, the Senator has sent up an amendment to which there's objection. When the machines are open, those in favor will vote yes, those opposed no. Secretary, vote your machines, please. Vote your machines. Are you through voting? You through voting? All right, close them up, please. 25 yeas, 10 nays. The amendment is adopted. You have further amendments?
I think
Next set of amendments set up by Senator Luno is set number 3878.
Senator Luno.
Thank you, Mr. President. Members, I'm proposing this amendment that it would allow a person who is convicted in these circumstances to have a parole hearing. Now, please hear that. To have a hearing, not to be paroled, but to have a hearing after they have served 25 years in prison. The change would be from 35 years in prison. We often try to compare Louisiana to other states, and we want to know what people in other states do. Well, the norm in other states is 25 years. There are a handful of other states that have more than 25 years, but I suspect that they're going to be talking to the United States Supreme Court before too much longer on their rules, just like we did. There are a few more states that have less than 25 years, but again, the norm in this situation is 25 years. Now, I think we all understand by this point in time that the U.S. Supreme Court has said that our statute is unconstitutional and we have to change that, so that's what we're in the process of doing. I want to talk to you a little bit further about this particular case from here in Louisiana, Montgomery versus the state of Louisiana. When the United States Supreme Court takes up an issue like this, in this particular issue, they dealt with the Eighth Amendment to the United States Constitution, and they said that our statute was unconstitutional. And I want to read to you a short excerpt from that case. The Supreme Court said, a state may remedy a Miller violation by permitting juvenile homicide offenders to be considered for parole rather than resentencing. And we talked about that earlier. But here is the part of the opinion that I want to point out to you. And in legal circles, this is what's known as dicta. And in that paragraph, the court cited a Wyoming statute. And they said in that statute in Wyoming, juvenile homicide offenders were eligible for parole hearings after 25 years. As a lawyer, that means to me that if our statute says 25 years, as the Wyoming statute does, that they say is okay, that's constitutional. And our law will be in lines with what's provided for in the Eighth Amendment of the Constitution. So that is why I am offering this amendment. I want to read to you one additional thing that the court said in the Montgomery case, and I think this is what's very important. The court said, extending parole eligibility to juvenile offenders does not impose an onerous burden on the states, nor does it disturb the finality of the state convictions. Those prisoners who have shown an inability to reform will continue to serve life sentences. This amendment does not mean that these people are not going to serve a life sentence. Every single one of them can. Senator Thompson, I heard your questions earlier about these people being able to be paroled. They can. That after 25 years, it would give them the right to have a hearing. I don't know the exact percentages, but I can tell you of the people that get paroled for these offenses, they're in the single digits. They are the lowest of the people that come before that board that receive these, that get paroled. There is occasionally somebody who would merit consideration of this. There is often people that come before here who do not receive consideration. So why am I here offering this amendment if that's the way I truly feel? 2 reasons. One is, as Senator Morrell talked about earlier, we spend hundreds of thousands of dollars defending unconstitutional statutes from the state of Louisiana. We shouldn't do that. We should be better stewards with our money than to do that. We cannot win that. The U.S. Supreme Court has already told us in a case from Louisiana what we have to do. We need to heed that warning, and we need to correct this statute. Let me tell you another reason we need to do that. In January, 39 of us stood right here, and we raised our right hand and we swore before God that we would uphold the Constitution of the state of Louisiana and the Constitution of the United States of America. The United States Supreme Court has told us what the Eighth Amendment to the U.S. Constitution means in this instance. So we have to ask ourselves, are we going to honor that oath we took? Or are we going to throw it out the window and ignore this case and say, we're going to thumb our nose at the United States Supreme Court and we're going to thumb our nose at the United States Constitution? I would ask your support of this amendment.
All right, sir. Senator Clay, do you have objection to it?
Yeah, and I'd like to speak.
And you have the right to do that. Proceed.
Thank you, Mr. President. I appreciate Senator Luno's enthusiasm and his analysis here. The range in what the other states are doing goes from 40 years before consideration to 15 years, as far as I could tell. That's the range, and that it's, I would agree that it's clustered in the 25-year range. But at the end of the day, what's going to prevail is what the 39 of us and the 105 others choose that's within that range. During the process, we saw different handouts, and one of the groups that was far lower in the number passed out some postcards with pictures of folks that they felt represented rehabilitation. And I put these pictures into my folder and held on to them and thought about if I didn't have any more pictures of my wife, my son, didn't get to see them grow up and become older, and those that have been the victims that go home every day to an empty house where their mother's not there or their brother's not there or their sister's not there, that have been murdered. We're not talking about anything but murder. I appreciate what he's saying. 25 years is a look back. Doesn't necessarily mean that they're going to be paroled, but I tell you, in my view, and that's how we, I guess, make money as a lawyer, we have disagreements on these things, but in my view, 35 years is perfectly constitutional. I do not believe that we'll be back on this issue, but if you believe in your heart that that's the thing to do, to go with one of these numbers, that's your choice. But I'm going to oppose the amendment because I'm going to have a hard time looking to the eyes of these families that have lost loved ones and say 35 years was enough for a first-degree murderer before they're considered for parole. So I respectfully ask that you reject the amendment.
All right. On the amendment, Senator Martini.
Thank you, Mr. President. Members, maybe much to your surprise, I rise in opposition to the amendment. Not that I think 25 years is a bad number. Not that I think 35 years is a good number. Quite frankly, I think both of them are figures pulled out of the air. The only reason that I believe, with all due respect to Senator Luno, I think the 25 years was his number because it's lower than 35 years. But I have a history in this building with the criminal justice system. I chaired the Criminal Justice Committee in the House for 8 years. I chaired the Judiciary B Committee here for 4 years. And I've been actively involved in that. And I want to see something happen. And while my heart tells me to vote for the 25 years, my head tells me that if this gets on there, those of us who will put it on there will not have control of the legislation. And if that happens, and they decide to have Representative Mack just sit on his bill, we get nothing. Then we can go back to Senator Morell's argument and Senator Claytor's argument about how much it's going to cost, because there ain't going to be anything out there. And nobody's going to be bound by 25 years. On the 300, I think they're going to be going to town. So I think the amendment that I put on the bill, not that it was better than Senator Luno's, but I think it's a fair amendment. I think Senator Luno's amendment is a good amendment. But you can put as many good amendments on this bill as you want. If the author of the bill says, thank you very much, I'm not moving it, we get nothing. And I want to see something come out of this. And I want to see something come out of this that is fair and reasonable. I think the bill in its current posture is one that I think if the District Attorneys Association looks at it, they can live with it. So I would regretfully ask you to defeat the amendment and to pass the bill. Thank you.
All right. Senator Gaddy, you wish to speak on the amendment? He waves. Senator Luno, you have a right to close on the amendment.
Well, first of all, I disagree with my friend Senator Claytor. The 39 of us are not going to have the last word on this, because in case you didn't know it, we have some people that grade our papers, and they're called the Supreme Court of the State of Louisiana and the Supreme Court of the United States. That's who's going to have the final say. And guess what? They've already spoke. They've already given us the key to the test. We know what the test is. The question is, are we going to ignore it? Like I told you before, when dicta is put in opinion, it's often put there to give you some guidance. And in that opinion, they stated the Wyoming statute that has the 25-year time limit. And again, if I'm hearing this bill for the first time and I don't know anything about it, you would think that people are just going to walk out of prison after serving 25 years. That's not what this is. It allows them the opportunity for their first hearing at that stage. Doesn't mean they get out of jail automatically. Most of these people will not get out of jail. But what it does, it puts this law into line with being constitutionally correct. It stops us from having to spend the money. And those of you in Revenue and Fisc with me know I harp on this all the time. We can't keep passing unconstitutional laws that cost us hundreds of thousands of dollars to protect. I'm not telling you you have to like this. I don't like it personally. But what I'm telling you is we took an oath, and we should uphold that oath.
The gentleman has sent up an amendment to which there is objection. When the machines are open, those in favor will vote yes. Those opposed, no. Secretary, vote your machines, please. Vote your machines. You through voting? Senator Martini, you voting? You through voting? All right, close them up, please. 10 yeas, 26 nays. The amendment fails to pass. Are there further amendments? All right, on the floor for the bill, Senator Perry, you wish to speak? He waves. Senator Gaddy, you wish to speak?
Thank you, Mr. President. I think what we have to remember here when we hear case names, and as a lawyer, I like to find out the facts behind a case. And in the Montgomery case, and I'll try to get through this, what happened is there was this East Baton Rouge Parish juvenile officer, and his name was Charles Hunt. And he was going by the school to look for some kids that had done some things that were wrong. And Mr. Montgomery, hiding in the woods, shot him with a .22 and killed him. A police officer. An East Baton Rouge Parish police officer. Now, we've talked about our oath, and I respect Mr. Luna more than he knows. But we also stood up here a few weeks ago, Senator Perry, with the great ceremony that you put on. And we met a lot of kids who lost their parents. And we honor every day in here. We honor. We couldn't do our job without the officers that walk the streets. And every day they put their lives on the lines for us. This is a tough bill. This is a tough thing to vote about. But you know, Becky Wilson is Charles Hunt's daughter. And she says that she had to forgive Mr. Montgomery. First trial, Mr. Montgomery was given the death sentence. But then he got another trial, and they gave him life. And then he tried to escape from prison with some other men. He was eventually successful in that. And what Miss Wilson says, who's now 60, she says, unfortunately, our sentence has no way of being overturned or commuted. We live with this forever. My mother served a life sentence without her husband. My brother, sister, and I have all served a life sentence without our father. My children, nieces, and nephews have served a sentence and of never knowing their grandfather. So I know we kind of trivialize this, and many of us kind of in our gut feel uneasy. And we were talking about this bill today. Y'all remember that? Kind of walking around saying, this just doesn't pass the smell test. There's something, there's got to be something more to this story. And so let's remember that for every victim, there's a family. And in this case, this young officer who died in 1963 serving the parish that we're sitting in was killed with a .22. He had been on the job 1 year and 4 months, and he was a juvenile officer. Now, I know we have to do some things when the Supreme Court tells us to. I just wonder if those folks in Washington, D.C. asked about Miss Wilson and her brothers and sisters and the grandkids and the nieces and nephews. I wondered if they considered the fact that this man was given not just one, but 2 trials. 2 trials. First sentenced to death, which is tough for a jury to do. Many juries decide not to do that. Then he got another trial and was allowed to have a life sentence. He's asked to be let out of jail many, many times, and they won't let him out. But if you could see the pictures that I'm looking at of Linda and Becky and Charles and Mike Hurt during Christmas of 1962, this was the last Christmas he had with his family before Charles was killed. So however you vote on this bill, I know there's no right way or wrong way to vote on this bill. I'm not trying to tell you how to vote. I just wanted y'all to consider the fact that this wasn't just a murder out on the street. This was an officer in the line of duty doing his job. And this family, the Hurt family, went through a lot during those 2 trials in the 60s. And they served their life sentence. I just hope that you'll consider that as you vote. Thank you, Mr. President.
All right, sir. Senator Martini, you wish to speak? He waves. All right, Senator Clay, you have a right to close on your bill.
Thank you, members. It's not often that this place gets quiet like this, so I want to thank you for taking the time to listen very carefully and make this important decision. I appreciate the debate that we had with Senator Martini on the issue of whether it should be prospective or not. So although we hadn't had JP come down here and holler about do our job in a while, I do want to thank you for doing your job today and listening to this very carefully, and I urge you to vote for the bill. Thank you very much.
All right. The Senator has moved final passage. When machines are open, those in favor will vote yes. Those opposed, no. Secretary, open the machines, please. Vote your machines, please. Vote your machines. You through voting? I close them up, please. 36 yeas, 1 nay. The bill is finally passed. Reconsider vote. Ladies, motion on the deck.